The publishing world was shaken by a major court decision that said book reviews and other critical writing should no longer receive the special protection from libel suits that critics' works had always enjoyed in the past. The case involved a book review in the New York Times that used the term sloppy journalism to characterize a book by author Dan Moldea about organized crime's alleged influence in the National Football League. A three-judge panel of the influential U.S. Court of Appeals for the District of Columbia ruled 2-1 that the author should be permitted to sue over the book review in the same manner as any other libel suit. It was an outcry in the media that this would stifle criticism, which had always enjoyed special legal protections against libel suits. So the Times lawyers asked the court to reconsider, and to the surprise of almost everyone, the court reversed itself and ruled unanimously that the Times was right and that the law should remain the same as it had been all along. There's much fascination in the legal world over this high-visibility U-turn by a court, and we're joined by Ken Starr, a former Solicitor General of the United States, who is now a Washington attorney and who filed a friend-of-court brief for publishing interests that supported the New York Times in this matter. Also, here's Roger Simmons, who represented author Dan Moldea and who first won the case and then lost it. Now, were you done wrong here?
Well, there are a number of things you have, points you've made that I would take issue with, but
okay, well, go
the
ahead.
case is far from lost. When Dan first walked into my office and I met him and began to learn about him and the case and the potential case, I think Dan and the counsel that worked with me in the case, Steve Tratner and Ed Law in my office, we all agreed that this case was going to go to the Supreme Court one day. And it's true that we've taken a sudden shock here. 10 weeks ago we were on the top of the mountain, now we're in the valley. This case, however, the Dan Moldea's case, was not a case, in our view, that changed the law in libel.
Well, but I gathered from remarks he has been quoted as having made since then, that he feels he was done wrong in the sense that the media piled on against the first decision and miraculously the judges changed their mind. Do you believe that?
Well, let me put it this way, Fred. The single point, the single difference between Moldea 1 10 weeks ago and Moldea 2 now was the constant pattern, the constant crescendo that built and built of media articles, editorials, articles written by all sorts of people and published in the media criticizing the review, criticizing the opinion. And Judge Mikva, in a very unusual move yesterday, was quoted in the Washington Post. Judge Mikva was on the panel. He was a dissent originally and part of the majority. Was actually quoted in the Post yesterday as having spoken to a press reporter, acknowledged that he certainly was aware of the mounting press criticism, and indeed felt sure that the two judges that had originally voted for us, very respectable judges, had in fact been impacted by this.
Let's ask Ken Starr, what else did change other than all this criticism?
I think in all honesty, Fred, the court had a fuller understanding of the implications of its opinion. Its first opinion was very far-reaching. It was a monumental opinion. It was a dynamite opinion, and I don't think that the court apprehended what it had done. And that may seem odd, but it happens. Judges are very busy.
Morning after.
Morning after, and then the Times comes in and says, here is what the court has done. It was supported by media interest, indicating this is very far-reaching, and the court has perhaps overread, as I think it did, and Roger's a wonderful lawyer, but I disagree with him on the state of the law. I think the panel opinion, the divided panel opinion, had just misapprehended what the law was. But they got it wrong the first time, and then, to their great credit, they said, we goofed, we made a mistake, and we're going to get it right, and they did.
Now, those two judges who switched, Judge Harry Edwards and Pat Wald, they are both strong-minded judges. And they had to know when they issued the first, quote, monumental decision that people were going to look at it and analyze it, and then suddenly they changed their mind. Is there any precedent? I don't know a precedent for this.
Judges change their minds, and you will see, to Judge Edwards's credit, when he begins the second opinion, he talks about, quoting Justice Stewart, that wisdom sometimes comes late, and it's better that it come late than never at all. And judges need to be open-minded about this. So I think this, by the way, Fred, is a great tribute to the court, and I feel very, very strongly that the court institutionally should be viewed as not having cratered and not been courageous to stick up for what it thought was right, but being open-minded enough to take a second look.
No one, I think, to my knowledge, would ever begin to criticize the intellectual integrity and the capability of Judge Edwards and Judge Wall. They're two of the finest judges in the country. There's no doubt about it. I think the question here that got created was what exactly the Supreme Court case in 1990, the Milkovich case, which preceded the filing of our complaint by about 4 months, what it really means. And that's the critical issue. We see Milkovich as cleanly and clearly and specifically wiping away the difference between opinions and normal news reporting. In the Milkovich case, it was...
Well, but pardon me for interrupting, because you're going to the issue here, and we'll go there in a minute, but it does seem, do you know of any precedent like this?
This, I think, is sui generis. It stands on its own.
Yeah.
It's unique. There are certainly instances, Mr. Starr well points out, where judges will change their mind where they've seen missed a case, missed a precedent, or something very different about a case that is brought to their attention. This is a case where the judges looked at it for 6 months before they ruled on the opinion. There was a vigorous oral argument. There was a 2-to-1 split on it. There was vigorous debate within the court over how to come out, and they came out passionately for Dan Moldea. 10 weeks later, they came out rather ambiguously for the New York Times, and I think what it points to is the need for a clarification of this area of the law.
But they came out enthusiastically in favor of one point that I think they had, notwithstanding the care and attention that it got in round one, that there was one very important principle. It's a basic principle of human communication, and that is the context of the statement matters. And the first opinion had simply swept that aside and said the Supreme Court in this Ohio wrestling coach case said a context really doesn't matter that much. And I think, with all due respect to Judge Edwards' first opinion, that was a misreading of what the Supreme Court said. There was language in the opinion. Milkovich was not the most carefully crafted opinion in the history of the Supreme Court. So there was language there that could lead a court astray. I think they were led astray by some loose language in Milkovich.
Milkovich is very specific. The test that is applied, that should be applied in this case, is and was whether or not the facts asserted in the review, the column, or the article are verifiable or not. This panel has moved away from that test and said not whether they're verifiable, not whether a reasonable juror could find them true or false depending on evidence, but now the plaintiff has to go back to the old standards that were enunciated in Ullman that were rejected, specifically rejected in Milkovich, and you got to look at what you call context, but really what the court called the context here is a book review is exempt, basically.
Well, but let me ask you now, isn't that the point? Wouldn't you agree that traditionally the law has permitted book reviews and columns, punditry, a little more leeway as far as expressing such views as this is sloppy journalism?
Some courts have, some haven't.
But shouldn't the law do that?
I don't agree with that for one reason. This country has moved toward a situation where we have very concentrated press, or a situation where people like Dan Moldea don't have the opportunity to get their viewpoint across the way, for example, Henry Kissinger or Norman Mailer do. When the New York Times came out with a book review that said his book contained things that absolutely weren't in there or were misstatements about what were in the book, Dan went to the New York Times and went specifically to Mr. Eskenazi, who had written the article, and asked him to please print these corrections.
Now,
and the Times first rejected the correction request, then they rejected his opportunity and his request to print a rebuttal piece.
But
where does he get the chance to have his side heard?
But if Mr. Simmons' view of the law prevailed, we really would not have book reviews and criticism as we've known it, would we?
I agree with that. I think Roger, and you can see what a good lawyer he is, and he was very persuasive the first time around, but I think his view of the law is quite pernicious. It's quite dangerous to the idea of robust, creative views with respect to that which Mr. Moldea put out in the public place. He chose to insert himself into the world of ideas and concepts and to be very provocative. his entire thesis, a very provocative thesis, was how organized crime has interfered with professional football. You can bet your bippy that that is a kind of subject that is going to get a lot of people very interested and very upset, and some strong views will be expressed. And you're quite right. Traditionally, book reviews and other forms of criticism have been viewed as an opportunity to express themselves. Now, one very important thing, I fully and completely disagree with the observation that there's now an exemption that anything goes in a book review. The opinion makes that very clear that that is not so, and re-articulates a standard that makes lots of sense. And the standard, very briefly, is, can that statement that is under challenge, that your client does not like, can it be viewed as a rational interpretation of the text itself?
But if your view prevails ultimately, and it's going to the Supreme Court, it will mean, won't it, that you can make mistaken, wrong, false statements in a book review that would subject you to being sued and recovery in an article.
Fred, you go beyond that. The panel, specifically in the closing passages, he says, the test they've adopted here, not just mistaken, but maliciously wrong book reviews with lies and libel in them, under the test they've adopted, will go unchecked. Those are their very words. And that is the problem.
Malicious falsehoods are okay in a book review under your formulation? I
don't think so. I think the formulation is, as long as you can find this rooted in the text of the book itself or the thing being referred to. Let's cut through this. What Judge Edwards said is, it will not do in the guise of a book review to say this person, Dan Moldea, is a complete liar, a drug addict, or to make any kind of accusation against his character. Absolutely not. Completely actionable. So too, anything that you're describing in the book.
The key here, the reviewer here was a setup. He was tied into the NFL. He was their mouthpiece, and he talked to the NFL to get their viewpoint. That was never told to the world. This was supposed to be a neutral review, and the Times advertised it that way.
But that then gets us, I think, to a critical point, and that is, let's assume, arguendo, that that is meritorious. What's the response to that? In my view, and I think this is the historic role of the First Amendment, is if people are going to insert themselves in it, they get out and say, I'm going to attack this newspaper for what it's done, I'm going to criticize them, and the correct response is not to go hire a very able lawyer and to file a lawsuit.
We have run out of time, I'm sorry here, but you're going to take this up. You're going to appeal.
I will appeal, and the proof of the pudding that we didn't impact on the First Amendment was a drumbeat of adverse opinions written between the first and the second Moldea opinions. The first Moldea opinion couldn't possibly have cut down on opinion writing. It was the most written about opinion in the history of libel.
We're going to have to quit, but you're going to appeal. There'll be a final decision, and we'll come back. We'll have you back again.
Thank you very much, Fred.
Well, we are going to have to take a break and then return for a